Okay, so if you've ever lived in a place with a homeowners association or an HOA, you know that relationship can get, well, a little complicated. Most of the time, it's about stuff like paint colors or keeping your lawn tidy, but every once in a while, a fight pops up that gets to the very heart of who's actually in charge. This is the story of one of those fights.
And it all boils down to this one really powerful question. Can your HOA just go out and buy a piece of land without asking you, the homeowner, for a vote? That's exactly what one woman believed happened, and she was so sure they'd overstepped their authority that she took them to court.
So here's how we're going to break this all down. We'll start with the accusation, dive into the case against the HOA, and then, of course, hear their side of the story. We'll look at the tiny detail in the rulebook this whole thing hinged on, see what the judge decided, and wrap up with why this case is a big deal for literally anyone living in a planned community.
All right, let's set the scene. Our story kicks off in a planned community called White Mountain Lake Vistas, and it all starts when the board of directors makes a decision that ends up sparking a full-blown legal battle, challenging the very rules that held their community together.
So who are the players? Well, on one side, you've got the petitioner, a homeowner named Olga Carnahan, and on the other side, the respondent, her very own Homeowners Association. And this wasn't just some angry email chain. This was a formal legal petition.
So here's the core of it. On October 14, 2019, Olga Carnahan filed the petition. And she was basically saying this: the HOA broke the law when it bought two empty lots, lots number 54 and 65, because they never got the approval they needed from all the homeowners.
So how exactly did she build her case? Well, this wasn't just a hunch. She laid out a specific timeline of events that she argued was clear proof that the HOA had broken its own rules.
And when you look at the timeline, you can see just how fast this all went down. She buys her home in 2017. 2 years later, there's a discussion at a meeting. Then, on October 11th, boom, she finds out the HOA bought the lots. And just 3 days after that, she's filing a formal complaint. Things escalated, and they escalated quickly.
Now, her claims were really specific. She wasn't just saying, this feels wrong. She pointed to the exact rule she believed they broke, Article 12.3 of their governing documents, the CC&Rs. She argued that rule required a 2/3 vote, a vote that never happened. For proof, she had the public records, the deeds, showing the HOA owned the land. And she added another really interesting point. By buying these lots, the HOA was actually losing money because now those lots couldn't be sold to someone who would pay HOA fees. But of course, there are always two sides to every story. The HOA saw things completely differently. From their perspective, this wasn't an illegal power grab. It was a totally necessary action that they were allowed to take.
The HOA's defense was pretty straightforward. First, they said, hey, our rules don't require a member vote for us to buy property. They also pointed out that they did talk about it with members at that September meeting, and everyone seemed to be on board. And why buy the lots in the first place? To fix a nagging drainage problem that was affecting the area. So, in their view, the board of directors acted within its rights and unanimously approved a necessary purchase.
And this, right here, is the absolute heart of the disagreement. Both Olga Carnahan and the HOA are pointing to the very same rule, Article 12.3, but they're reading it in two completely different ways. It's like they're looking at the same words, but seeing opposite instructions. And this is where it gets really fascinating. You have all these arguments, all the legal paperwork, the meetings, and this entire massive dispute boils down to the legal definition of just one single word tucked away in the community rulebook. Okay, so here it is. This is the exact text from the rulebook. The whole section, Article 12.3, is called Amendments. And it says, this declaration may be amended by the written approval or affirmative vote of 2/3 of the membership. I want you to really focus on that one word, amended.
Everything hinged on this word. Ms. Carnahan's argument was that buying property was such a big deal, it was basically an amendment to how the community was set up, so it needed that big 2/3 vote. The HOA, on the other hand, had a very, very different interpretation.
So let's get clear on what an amendment really means in a legal sense. An amendment is when you change or add to the rulebook itself. The HOA's whole argument was that they weren't changing any rules. They were just taking an action, buying land to fix a drainage issue that was allowed under the rules that were already in place. It's a subtle but absolutely crucial difference.
So, with these two totally conflicting interpretations on the table, the case finally went before an administrative law judge. It was now up to a neutral third party, the court, to read that fine print and make the final call.
Now, before we get to the verdict, we have to talk about a super important legal concept called the burden of proof. What it means is the person who makes an accusation is the one responsible for proving it. It's not on the HOA to prove they didn't break a rule. It was on Ms. Carnahan to prove that they did.
So, what did the judge find? The ruling was crystal clear on every single point. Did the HOA violate Article 12.3? The judge said no, because that article is only for amending the rules, not for buying property. So, was a 2/3 vote required? Nope. Again, the rulebook didn't say one was needed for this kind of action, which led to the final conclusion. Ms. Carnahan had failed to meet her burden of proof.
And with that, on January 13, 2020, the final order came down. The petition filed by Olga Carnahan was officially dismissed. The judge found that the HOA had, in fact, acted within the powers granted to them by the community's own governing documents. So, okay, a neighborhood dispute gets settled in court. Case closed. But what can the rest of us actually learn from this? Well, this case is a huge, flashing warning sign for anyone who's part of a homeowners association. This whole story really leaves us with 3 huge takeaways. First, words matter. A lot. The entire outcome here swung on the precise legal definition of the word amend. Second, you absolutely have to know your documents. Your HOA's power isn't based on what feels fair or logical, it's based on what is explicitly written down in the CC&Rs. And third, if you decide to challenge your HOA, remember that the burden of proof is on you to show exactly which rule they broke.
And all of that leaves us with one final big question to chew on. It's really easy to just assume you know how things work in your own community, but after seeing how an entire legal battle can turn on a single word, it's probably worth asking yourself, do you really know the rules that govern your own home?